comments. We have about 1 hour in this session. We'll commence at 9:20 and we'll go up until 10:20. Each delegate will have about 10 minutes to speak. So at about 8 minutes into each session, please come, feel free. At about 8 minutes into each session, either Lady Justice Mwale or I will raise up a plaque to let you know that you have 2 minutes left. Please, yes, Mabele may take a free seating. I don't know if we'll have space for 2 delegates per country, but let's try and see, maybe 1 per country, we see. All right, I think the House is full. Tech team, please check if we have a representative from Madagascar joining online who would like to speak. If you just put, I'll see. All right. We need some tech help here as well for the projector, please, for the cable. Yes, fantastic. All right, Amy, we've been advised that you need to turn on your camera if you have enough bandwidth so that we may see you. Or you can speak back so that we know that you're there. Also, tech support, we need some support here for presentation in the event. Our delegation, no. We'll speak each country first as per the agenda, but Mozambique is coming up first and they would like to make a projection. Thank you. So panelists, we will have, as we mentioned, 10 minutes. At 8 minutes, we will just raise the flag to just let you know that you have 2 minutes left. Other participants, because today is a bit busy, I would request that if you have outstanding questions, which will most likely arise for each presentation today, that we jot them down, and then tomorrow we have a 2-hour session mid-morning into the afternoon where we'll be able to discuss all these issues and then link them to what we see as matters arising and how we can move this item forward. I would like to also urge you and request you to think about how we can move this further into your country so that your colleagues can also be part of this experience. And if there are key issues that you see are critical for your country, happy that you note them down so that whenever we have these sessions in your country, which we intend to do with your support, then we'd be able to highlight those various issues that are really critical from your country, because I know this is a very big document and it might not encompass all if we have a 3-4 meeting in each country. So without further ado, thank you so much. Amabele will allow us to start with maybe Zambia or Tanzania as they sort your presentation out. Yes, maybe we can start with another country as they sort your... Yes, maybe we can start then this way from the end of the day with the Republic of Tanzania. Thank you very much.
Good morning, everyone. In Tanzania, we were set to present a case of Milinga, but we refer it as Wasichana case. That was famously known in Tanzania, means girls. In this case, there were 3 perpetrators, namely Jacqueline Patrick Milinga, Mary, Judith, and Simon Alex Mgaya. It was on 4th September 2015 at Tanzania-Kenya border, a place known as Namanga. 10 girls were arrested by migration officers for traveling from Dar es Salaam, Tanzania to Nairobi, Kenya without having a valid traveling documents. Upon their arrest, that was where the truth of the mission was revealed. When they were interrogated, the 10 girls stated that they were accompanied by 2 perpetrators who had already crossed the border. Because the Tanzanian police officers did not have jurisdiction to arrest the perpetrators, as they had already crossed the borders to Kenya, it was the 10 girls who contacted them and made them come back to Tanzania border. And that's where the 2 perpetrators, who were Jacqueline Patrick and Mary Judith, were arrested and their phones were seized. The girls stated that they were recruited to go and work in Nairobi, Kenya, in a massage parlor, bar, and salon. The requirements for their recruitments were that they needed to wear half naked, makeups, and even before the recruitment, their photos were taken and sent to someone else who was in Nairobi. And after the perpetrators were arrested, their phones were seized, their cell phones. And upon examination of the phones, a conversation of the perpetrators and a person whom the girls were to be handled in Nairobi were seen. Even the pictures that were sent to him were retrieved. And that is, in short, the facts of the case. The perpetrators were then arrested and charged with the offense of trafficking in person, contrary to Section 4, subsection 1, A and 5 of the Anti-Traffic in Person Act, number 6 of 2008. The outcome of the case: all accused persons were convicted and sentenced to pay a fine of 10 million shillings or to serve an imprisonment of 5 years. This case was prosecuted in the subordinate court, and the subordinate court only has a jurisdiction to give a sentence of 5 years imprisonment and not more than that, although the law provides for a greater punishment of 10 years. The 2 perpetrators could not be satisfied with the decision of the subordinate court. They appealed to the High Court, in which the High Court upheld the conviction. There is now a pending appeal to the Court of Appeal of Tanzania, yet to be determined. The strength of this case was, although the act of exploitation did not take place, but the electronic evidence which was retrieved. Hello? Okay, now I think everything is okay. I can proceed. The electronic evidence which was retrieved from the perpetrators' cell phones helped to establish that the purpose of the girls to be recruited was not as it was put forward to them, but rather for sexual exploitation. The challenges that we think were there, first of all, not all victims were ready to testify in court, because one of the victims was the blood sister of the third perpetrator. Hence, it wasn't easy for her to turn in and testify against the brother. Also, we think more evidence would have been retrieved by seeking mutual and legal assistance from Kenya, because the main perpetrator could not be arrested, and even the girls were taken to Kenya where he resides. So the truth was never revealed because no evidence, no investigation was done on that part. That's all we had from Tanzania on the case. Thank you for your listening.
So, is Mozambique ready? Please go ahead.
Muito bom dia a todos. O caso que nós vamos apresentar não sei se já estão a traduzir, como vou falar em português. O caso que nós vamos apresentar é um caso que ocorreu na província de Gaza. A província de Gaza é uma província de Moçambique que fica na região sul do país e tem a capital Xai-Xai, com o nome Xai-Xai. A província de Gaza situa-se a cerca de 210 quilómetros da cidade de Maputo. A minha colega vai proceder à descrição dos factos deste caso e, posteriormente, eu farei o enquadramento jurídico que foi dado pelo Tribunal Judicial da província de Gaza. Obrigada.
Tech support, could you help us so we can see the presentation?
Bom dia. Nós enviamos a apresentação por e-mail para a equipe técnica. Não sei. Mas para não perdermos tempo, vamos fazer a apresentação assim, infelizmente. Eu vou fazer a apresentação dos factos do caso Gole. Este é um processo que foi registrado sob o número 115/PPRG1 na província de Gaza e foi acusado no dia 9 de maio de 2017. Este processo teve como arguidas 4 mulheres, que foram a Ana Ezequiel Gol, Fátima Zunguze, Joyce Maluleke e Lina Américo Munguambe. Consta do compêndio. No dia 10 de fevereiro de 2017, a arguida Ana Ezequiel Gol deslocou-se à vila de Massingir, que é um distrito na província de Gaza, onde contactou a Joyce Vicente Maluleke. E juntas arquitetaram um plano para sequestrar um menor. De acordo com o plano traçado por estas, Elina Munguambe ficou encarregue de identificar a casa do menor, Joyce Maluleke encontraria um comprador interessado e Ana Ezequiel Gol seria a recrutadora deste menor. Para materializar esse plano, no dia 31 de março de 2017, aproximadamente um mês depois, a arguida Ana Ezequiel Gol, estando na cidade de Maputo, que é a capital do Moçambique, contactou a Elina Américo Munguambe e informou-a deste plano. Já temos aqui uma quarta pessoa que entra no esquema. Elina Munguambe dirigiu-se à residência da vítima, que se encontrava a brincar com os irmãos, e numa forma de reconhecimento disse-os para não brincarem com um disjuntor elétrico. E voltou à sua residência. Mas a ideia dela era tentar perceber se a avó daqueles meninos estava em casa. Algum tempo depois, voltou à mesma residência e pediu água para beber. Deram-lhe água e regressou. Foi quando ela percebeu-se que a avó, que é responsável dos meninos e da vítima, já não se encontrava naquele local. De seguida, no mesmo dia, Ana Ezequiel Gol e Elina voltaram à residência da vítima, Bento José Zaval, e, aproveitando-se, como me referi anteriormente, da ausência da avó, chamaram-no pelo nome, porque naquelas encetadas de reconhecimento ela já sabia que a vítima se chamava Bento, chamaram-lhe pelo nome e informaram-lhe para ir ao mercado que a avó estava-lhe a chamar. O menino aceitou e seguiu as arguidas em direção ao mercado. Pelo caminho, disseram que a vítima deveria ir à África do Sul para se encontrar com a mãe. Hão de perceber que a província de Gaza, ou a região sul de Moçambique, tem uma tradição muito grande de imigração para a África do Sul. A província de Maputo, Gaza e Inhambane são províncias que o sonho de todos é ir para a África do Sul. Tem a República da África do Sul como Eldorado, então todos imigram para a África do Sul. E neste caso também, a mãe desta vítima estava na África do Sul. E ao informarem o menino de ir à África do Sul, ficou todo satisfeito e seguiu as vítimas, e seguiu as arguidas, alegando que iria para a África do Sul. Embarcaram num transporte semicoletivo de passageiros, mas com destino à província de Gaza, e não para a República da África do Sul. Pelo caminho, Elina desceu no distrito de Maracuene. Distrito de Maracuene dista a 30 quilômetros sensivelmente da cidade de Maputo, alegando que tinha que voltar para cuidar do seu bebê e já tinha terminado o seu papel naquele programa que elas tinham. Entretanto, a arguida Fátima Ernesto Zangarote já se encontrava... estão a pedir para ser um pouco mais devagar. Entretanto, a arguida Fátima Ernesto Zangarote já se encontrava no distrito de Maracuene à espera de Elina. Vamos perceber que quando chegaram a Maracuene, uma desceu do carro, alegando que iria cuidar do bebê, e entrou no mesmo transporte uma quarta pessoa, que é Fátima. Tomou o mesmo transporte com a Ana e seguiram para o distrito de Chokwe, na província de Gaza, onde supostamente iriam fazer a entrega daquela criança. Entretanto, com a demora da vítima, o irmão mais velho achou estranho e seguiu até o mercado onde a avó estava para perguntar por que o irmão mais novo não regressava. Ambos dirigiram-se à residência de Elina, que já tinha regressado de Maracuene, onde ela tinha descido, e respondeu que não conhecia o paradeiro de Bento e apenas teria ido à residência daquele para alertar que estavam a brincar com um disjuntor elétrico. Imediatamente foram alertar a polícia e iniciou-se um trabalho para tentar localizar aquela criança e, felizmente, na mesma data, foi possível encontrar o menor no distrito de Chokwe. antes de poderem conseguir fazer aquela entrega. De seguida, Excelência Doutora Mabélia Chuquela vai continuar a fazer a qualificação destes casos, destes fatos.
Eu vou tentar rapidamente fazer a qualificação dos factos, mas antes gostaríamos de dizer que Moçambique segue o sistema Civil Law, que é conhecido como sistema romano-germânico, que tem como a lei a principal fonte imediata de direito. No caso de Moçambique, a jurisprudência e a doutrina também são fontes de direito, mas são fontes secundárias. Neste caso, a acusação foi pelo crime de tráfico de pessoas, na forma frustrada, e na altura a moldura penal abstrata deste crime era de 16 a 20 anos de prisão. Como circunstâncias agravantes, a acusação considerou a premeditação e o pacto, e como circunstâncias atenuantes considerou a confissão, principalmente em relação às arguidas Ilina Muguambe e Fátima Zangorote. Aconteceu, porém, que, na sentença, o Tribunal Judicial da Província de Gaza considerou que não estavam reunidos os elementos do crime de tráfico de pessoas e entendeu, portanto, que não foi provado o elemento de exploração, portanto, a finalidade, e pelos depoimentos prestados no julgamento, não transpareceu na convicção do tribunal que tivesse ocorrido a exploração e que também as arguidas não tinham intenção de explorar o menor. E foi com base nestes fundamentos que o tribunal condenou por um outro crime que, na nossa legislação, designa-se crime de subtração fraudulenta de menor de 12 anos, que está previsto no artigo 212 do Código Penal. Uma das arguidas foi absolvida porque o tribunal considerou que não tinha conhecimento da intenção das outras arguidas de retirar a criança por meio de fraude e sem a autorização dos seus representantes legais. As arguidas Ana Gole foi condenada a 5 anos de prisão, Joyce Malulek a 2 anos de prisão e Elina Muambe a 2 anos de prisão. Outro aspecto, antes de terminarmos, gostaríamos de dizer que o direito penal moçambicano rege-se pelo princípio da tipicidade. Quer dizer que é preciso que haja adequação de um ato praticado pelo agente às características que o enquadram a norma descrita na lei penal como crime. Também permite o direito penal moçambicano que o juiz, na fase de julgamento, pode proceder à alteração, à qualificação jurídica dos factos descritos na acusação ou na pronúncia, desde que a alteração não determine crime diferente daquele que foi acusado ou pronunciado. Mas também que não caiba pena maior do que o crime pronunciado ou acusado. E foi com base neste artigo que o Tribunal Judicial da Província de Gaza entendeu que deveria qualificar os factos não como tráfico de pessoas, muito menos como tentativa de tráfico de pessoas, mas pelo crime de constrangimento do menor a abandonar a casa dos seus pais. A questão que este caso nos traz é exatamente perceber quais as razões que levaram o Tribunal de Gaza a não considerar o crime de tráfico de pessoas e muito menos este crime na sua forma tentada. O Código Penal que está neste momento em vigor, o que estava na data em que os factos ocorreram, nós tínhamos um Código Penal que considerava como tentativa de um crime os seguintes elementos. Portanto, para haver tentativa de um crime, era preciso haver intenção do agente, execução começada e incompleta dos atos que deviam produzir o crime consumado. Era também necessário que tivesse ocorrido suspensão da execução por circunstâncias independentes da vontade do agente e, por último, que o crime consumado fosse punido com pena maior. Portanto, são estes aspectos que nós gostaríamos de trazer em relação ao caso Gol, mas, naturalmente, na altura do debate, nós podemos discutir as questões relacionadas porque é que não foi provado o tráfico de pessoas e muito menos a intenção, portanto, não foi provada nem a tentativa do crime de tráfico de pessoas. Não podemos nos esquecer que, para termos o crime de tráfico de pessoas, é importante que estejam reunidos os três elementos: a ação, meios e a finalidade, que neste caso a exploração. E vamos discutir efetivamente se estes três elementos estavam ou não reunidos no caso Gol. Muito obrigada pela vossa atenção.
Thank you very much. Okay. Thank you very much, Mozambique. I'm going to ask the next speakers. Is that Zambia or who's next? Is it Zambia or DRC or Malawi? Is it Malawi? So just before you go on, please look at me from time to time so I can tell you whether we're still in time or not. And for the rest of the participants, the cases that we're hearing today are focusing on subtle means of control. So what we're listening out for is how the trafficker subtly controlled the victims. So as you make your presentations in this panel, please remember to highlight that aspect. And then questions will be dealt with at a later stage. Right now, we just want to hear from the participants. Thank you.
Thank you so much. Good morning, distinguished delegates. Maybe just an observation, my lady. I think we are looking at the cases where exploitation was not proven.
Yes, thank you. I went ahead. Thank you. So yes, please try to highlight that aspect as you make your presentations. Thank you.
Malawi is debating the Republic versus Bandawe case. In this particular case, the perpetrators were 3 Malawians and 1 Kenyan. The 3 Malawians were arrested and brought before the court, where the Kenyan was not arrested and prosecuted as he is still at large. The accused herein were charged with 2 counts of trafficking in persons contrary to Section 14 of the Trafficking in Persons Act. Each of the two counts involved two victims. The particulars of both counts are that the accused persons, by means of fraud or deceit, recruited and transported the victims to Lilongwe with an intention of transferring them to Dubai through Tanzania and Kenya. So the first group was recruited in a place known as Salima, which is about 100 kilometers from the said Lilongwe. And the second group was recruited from Mitundu, which is about 60 kilometers from Lilongwe. So in deciding the case, the court took into account a series of activities that led to the commission of the offense. So in the first count, the accused approached the two victims and told them that they would find employment in Kenya. Similarly, in the other count, the other accused also approached the other two victims with the same promise of employment in Kenya. So the court found that the recruitment process in the recruitment process, the accused persons were wholly responsible for processing the travel documents. Namely, they collected and filled the passport application forms for the four victims. They paid the application fees. They collected the 4 passports. The victims only appeared at the immigration offices for photographs and did not participate in the filling the forms for the application forms. The accused persons collected the passport forms without involving the victims, and the victims only saw the passports at some restaurant after they had already left their respective homes. At the said restaurants, the accused briefed the victims on their trips to Kenya via Tanzania. The court found that there was fraud behind the application, payment, processing, and collection of passports. The evidence before the court also showed that the accused persons had processed, without the knowledge of the victims, yellow fever books, or what we can call health passport books, showing that the victims had been vaccinated against yellow fever, when in fact the victims had not been vaccinated. The victims were only shown the yellow fever books at a restaurant, at the very same restaurant where they were shown the passports, and in one of the books, the first accused endorsed the phone number of the person who would receive them in Tanzania, without disclosing the name of the person. Based on the above circumstances, the court concluded that the accused persons recruited the 4 victims through fraud or deception with an aim to exploit them, and convicted the accused persons of trafficking in persons. Now, what are the observations from the above facts? First, it is evident from the facts that no exploitation had taken place at the time police officers intervened and arrested the accused persons. However, the court held that a complete offense of trafficking in place had been committed. Under Section 2 of the Trafficking Act, actual exploitation needs not to be proven. Proof of intention suffices. So long you prove that there was intention to exploit, then the accused person can be charged of a complete trafficking of persons offense as opposed to an attempt. So an offense is proven if the intention to exploit is proven. The court found that the fraudulent manner in which the travel and health documents were obtained and the pretext that the victims would secure employment in Kenya were sufficient evidence that the intention for the recruitment was exploitation. Hence, the offense of trafficking in persons was committed. Fraud may be inferred from the circumstances, namely, the fact that the person had to pay the passport fees themselves. So for the 4 passports, the amount was about $400. So the payment of the $400 showed that they were up to something sinister. They were up to some sinister motives and showed evidence of the perpetrators or the preparation for the crime. The fact that there was a chain of organized crime with some members situated in Malawi, others in Tanzania and Kenya, also shows that the aim was to exploit. The fraudulent preparation of the Euro fever books at a military hospital without the actual attendance of the complainant, the fact that the passports and Euro fever books were held by the accused persons and not released to the complainants, and at the time of the arrest, they were found in the possession of the accused persons. So the court looked at all these and concluded that there was intention to exploit and convicted the accused persons of trafficking in persons, although the exploitation had not yet taken place. Thank you so much for your attention.
Thank you very much, Malawi. And we'll move on to Zambia on the Mwewa and Kasonde cases.
Morning. Yes, so as the moderator has spoken about, we're going to present on the Mwewa and Kasonde cases. These cases are actually similar in the facts, in fact, actually. The salient facts are that in Mwewa, the two accused on one hand, and Kasonde on the other hand, both these people went and offered businessmen people for sale, children for sale. And these businessmen, having been offered these people for sale, contacted the police, and in both cases, sting operations were conducted, and these accused persons were arrested. In the lower court, both sets of accused were convicted. Interestingly enough, this was in the same province. The only difference was that in Bupemwewa and another, the accused persons actually entered a plea of guilty, and so a statement of facts was drawn up, which was agreed to by both the prosecution and the defense. And on that basis, the lower court convicted them. While in Kasonde, there was actually a trial, which ended up in a conviction. Now, according to our laws, the minimum mandatory sentence is far above the powers of the magistrate who convicted sentence, and so these matters were sent to the High Court for sentencing. Interestingly, again, these matters came before the same judge, the same criminal session, and in both cases, the judge relied heavily on the Mulumbila case. I think it's in the digest, the facts are there. And I forgot to mention, they were both charged under Section 7.1 of our Anti-Human Trafficking Act, which is advertising, publishing, or broadcasting information that suggests or alludes to trafficking. Now, in both these cases, the court held that that there was no advertisement that was made by both accused sets of people. And that because there was no advertisement and there was no evidence led by the prosecution to show that there was an intent to exploit these victims, and it relied heavily on the Mulumda case, as already mentioned, in which it was stated that it's not enough for you to show that people were moved or people. In fact, the facts in the Mulumbila case are quite different. It'll become telling later on, I think, when we talk about the issues with the judgments. In Mulumbila, these kids were smuggled from Congo into Zambia, and then they were caught in the process of being smuggled into Namibia. But the Court of Appeal exonerated the accused in Mulumbila, saying that there was no evidence led to show that there was exploitation or an inference of exploitation from the accused, and that the means of trafficking were not shown, that is, the coercion and the like. And so the court in Mwewa and Kasonde relied heavily on this case in holding that they did not show, the prosecution did not show an inference of exploitation or exploitation, and that they did not prove the advertisement. Now, we have a few issues with this, respectfully. if we look at our Anti-Human Trafficking Act, it mentions specifically like the exploitation involves slavery or any forms akin to slavery. And I think you agree with me that if I come and offer you a person for sale, that's akin to slavery. I mean, I'm commodifying somebody. So respectfully, I believe that the putting up for sale alluded to trafficking. And the exploitation was actually shown, or rather an inference of exploitation could be inferred from that case. Another one is the narrow view of the word advertisement. I think the court relied on a very, very restrictive view of advertisement. And even that being the case, Section 7.1 also speaks about publishing, printing, and of course, publishing is communicating to a third party. So if I tell you I have a person for sale, I've published that information. The court could have found solace there, we believe. Another issue that the court looked at was that the prosecution did not show the age of the victims. The funny thing about Section 7.1 is that if it says alludes to trafficking, then you must go to Section 3 for the definition of trafficking. That's where the exploitation is coming in. Well, 3.1 talks about trafficking in persons, and 3.2 talks about trafficking in children. And the court held in Mwewa and Kasonde that the fact that the prosecution had not proved the age of the children was a factor that would lead it to an acquittal. Again, with respect, that's difficult for us to understand because I don't think the age is an ingredient here, since 3.1 is always going to come to our rescue. And so the accused in both cases were exonerated of the charges. I think the only, as I mentioned earlier, the difference that can be drawn from the two in terms, or the biggest problem rather, with these cases as we see it, is that there was no investigation done as to the actual existence of these victims who are supposed to be trafficked. And that was a weakness. But if we look at the technicality of the trial, in Wupemwewa, I think there was a statement of agreed facts. And under those facts was agreed that these people existed and their ages were in the facts. And since these facts were agreed to by both the court and the prosecution and the defense, the court was entitled to take those facts as facts. And so it was a fact in those cases that these people existed. And I think an conviction there would have been proper. In the second one, the court did allude to the fact that the specific person in the advertisement had not been proved. So in the second one, I believe maybe the court could have found solace there in exonerating. That's in Kasonde. Though that is not the reason why the court exonerated Kasonde. To answer the question, does the kind of exploitation need to be proven? I think the answer is yes. Our Human Trafficking Act goes to many, many lengths to describe exploitation, slavery, passports, and all of that. And also, as a matter of practice, if you're going to be prosecuting someone, I think your statement of facts needs to show them what kind of exploitation you're talking about to enable this person to make his defense. I don't think you can just go and say, well, for exploitation. You must at least state what kind of exploitation you're talking about. Otherwise, you might be talking about one thing and they might be talking about another. So I think as a matter of practice, yes, you need to prove what kind of exploitation is going on. That being said, I think that's it from us. Thank you very much for your attention.
Thank you very much, Zambia. We'll now move on to Madagascar, who are appearing online with the AMA case.
Tech team, we're moving to the person who's on, the representative from Madagascar who's on Zoom. Please, thank you. Sorry, sir, we cannot hear you. Perhaps you might unmute your... Thank you.
We still can't hear you.
Apologies, sir, Mr. Ame, representative of Republic of Madagascar. We are still trying to sort out the tech issues. Please, if you can give us 1 minute, we sincerely apologize for that.
So while we're waiting for Madagascar to sort themselves out, I hope we've noticed a thread running through these cases. Maybe I can just also highlight the difficulties in cases where the exploitation did not transpire. What approach are the courts showing us? There doesn't seem to be consistency as to the quantum of evidence that's necessary to convict where the actual exploitation didn't occur. We have seen from countries such as Malawi and Tanzania, the Milinga case and the Bandawe case, that even though the exploitation did not happen, the courts did convict. But there is a very big difference between Malawi and Tanzania in that in Tanzania, the type of exploitation envisaged was actually proved. There were pictures of the women, there were pictures, there was all sorts of documentary evidence passed between the parties. Whereas in Malawi, all that sufficed was an intention to convict. So you can see the difference. Zambia has pointed out that, in Zambia, an intention to exploit is not sufficient because the prosecution has to lay out the charge specifically for the accused person to defend themselves. And I think that because the Bandawe case in Malawi was never appealed, it's a subordinate court decision, we may see something different if if the court goes, if the case went on appeal, but we don't have the luxury of higher court jurisprudence, as we all have the same law that says, a charge should be sufficiently particular for the accused to defend themselves. So that would be interesting to see what would have happened if it ever went on appeal. Are we ready to hear from Madagascar? So as I said, we will have some time towards the end in which we can debate the validity of these issues and how we can work within our jurisdictions to overcome the seeming challenges. I think another common thread about the presentations is that most of the times the presenters have raised issues about the courts handled the case, that they feel that certain issues were not explored deeply enough, and maybe there would have been a different result if those issues had been explored. And as Jeptum said at the beginning of this session, we will be reaching out to the individual countries on how we can roll out some assistance on some of these technical issues. And perhaps countries can start noting down these challenges that they're facing, and then we can figure out together what kind of programs we can put on to overcome some of these challenges. Is Madagascar ready? I did say there wasn't going to be any question and answer, but since we have, since we're waiting for Madagascar to join us, if anybody has a comment from the floor, you are free to comment on what has transpired so far. Unfortunately, if Madagascar comes on, I'll have to stop you. Yes, Angola.
Sim. Portanto, esta pergunta vai para as minhas colegas de Moçambique. Realmente gostaríamos de saber, melhor, perceber melhor que elementos da tentativa não estavam, tanto que elementos da tentativa do crime de tráfico de seres humanos não foram verificados neste crime, porque pareceu-nos pelo menos que existiram ali alguns atos preparatórios pelo facto de terem levado o rapaz para muito longe da cidade, e não percebi também qual é que terá sido a defesa das acusadas em explicarem melhor o motivo do facto de o terem levado para tão longe da cidade de Gaza. E também gostaria de saber se o Ministério Público recorreu desta decisão e se já terá alguma decisão do Tribunal Superior ou se o processo está em curso. É tudo. Obrigado.
Yes, Mozambique, go ahead. And unfortunately, if Madagascar comes on, I'll have to cut you short. So.
Queríamos agradecer as questões que são colocadas pelos colegas de Angola. Dizer que, neste caso, como nós dissemos, o Tribunal Judicial da província de Gaza considerou que não havia também tentativa do crime de tráfico de pessoas, porque um dos elementos da tentativa é a intenção do agente. E, em sede de julgamento, houve depoimento da avó do menor, e o menor também, portanto, prestou depoimento. E destes depoimentos entendeu o tribunal que não estava, portanto, não transpareceu a intenção que as arguidas tinham de, portanto, proceder ao tráfico daquele menor para a África do Sul. E se tiverem prestado muita atenção, digamos assim que o que aconteceu foi que houve exatamente atos preparatórios, mas que efetivamente esta execução foi interrompida, foi, portanto, incompleta, porque o menor foi, portanto, ou foi descoberto, o caso foi descoberto muito antes do menor ter chegado à África do Sul. Este menor foi, portanto, levado da sua casa, na província de Gaza, e o caso, portanto, foi encontrado numa outra jurisdição, no caso foi no distrito de Maracuene, na província de Maputo. Portanto, o tribunal entendeu que os elementos da tentativa, que normalmente na nossa legislação, e nós na nossa apresentação fizemos menção que são elementos cumulativos, portanto, tem que estar reunidos todos estes elementos, que são a intenção do agente, é a execução começada e incompleta dos atos que deveriam produzir, portanto, o crime na sua forma consumada, e também tiver havido suspensão à execução por circunstâncias independentes da vontade do agente, e o último elemento é que o crime consumado tem que ser punido com pena maior. Se notarmos que poderia ter havido ou preenchido alguns dos elementos da tentativa, mas um elemento crucial, que era exatamente a intenção do agente, não ficou provado. E como são todos os elementos que devem ser, concorrem ao mesmo tempo e devem estar reunidos, o tribunal entendeu e afastou a tentativa de tráfico, e mais como havia na acusação descrição de factos que poderiam, portanto, que contemplavam um outro ilícito criminal, portanto, existia um outro crime, o tribunal condenou as arguidas por esse outro crime, que foi o caso de constrangimento de menor a abandonar a casa dos pais. Em relação a recurso, infelizmente, o Ministério Público conformou-se com a decisão proferida pelo Tribunal Judicial da província de Gaza e não recorreu para o Tribunal Superior de Recurso. E teria sido até interessante, e muito bem, como disse a moderadora, se este caso tivesse sido levado a Tribunal Superior, poderíamos explorar um bocadinho mais estas questões que estão-se a colocar. A intenção, a tentativa nos casos de tráfico e como é que isto deve ser apurado nos casos em concreto. Muito obrigada.
Thank you very much, Mozambique. Let's give Madagascar another chance.
Just to explain, we are having some challenges hearing the colleague from the representative from the Republic of Madagascar. We have tried to look at the tech side, and the technical team cannot still hear him. And as well, we've asked him to exit the meeting and come back again, and we still can't hear him. Perhaps if there's any colleague who's online on the Zoom, maybe you can try and say something. We see whether it is a challenge from the Zoom in totality or it's just specific to the delegation from Madagascar, Mr. Aime's computer. I know Rahel is online, Melissa is online, Chisomo is online. So maybe if one of you can just say something and we can see if we can hear you, colleagues from the Zoom side. Or if you can let us know whether you hear us as well.
We can hear you.
Oh, good. So we can
Vous
hear
m'entendez?
Rahel. Thank you, thank you. So
Oui,
it
allô?
seems it's a
Oui,
challenge.
vous m'entendez, l'Assemblée?
There we are.
D'accord. Je vous remercie de m'avoir donné la parole. En fait, m'avez aimé
Sorry,
être parmi
Madagascar.
vous dans cette
Just to let you know,
assemblée.
you have 10 minutes, so we'll be stopping you
Mais
at 10:28.
d'accord, merci beaucoup. Comme je vous disais tout à l'heure, on avait aimé participer à ce séminaire sur place, mais malheureusement, cela n'a pas été possible. Ainsi, on a dû participer à ce séminaire en ligne. Et mon collègue délégué de Madagascar aussi a un peu de problème sur le plan technique. C'est pour cela que vous n'arrivez pas à voir le son, de l'écouter. Mais j'aimerais apporter mes interventions sur les cas qui s'est produit et qui a été traité dans les juridictions de Madagascar. En fait, mon collègue a déjà préparé son intervention, mais malheureusement, comme j'ai dit tout à l'heure, il n'a pas pu intervenir suite à des pannes techniques sur son micro. Ainsi, je vais vous exposer un cas qui s'est produit à Madagascar et qui a été traité dans le tribunal, dans les juridictions, au tribunal de première instance d'Antananarivo. En fait, c'est un cas où il y avait des demandes d'emploi à l'étranger, à Maurice plus exactement. Et pendant ce temps-là, beaucoup de jeunes malgaches ont répondu à cet appel offre d'emploi. Ce qui nous a étonné, c'est que l'offre d'emploi précisait que les travailleurs doivent être des jeunes filles qui sont déjà majeures et qui sont encore en âge de bien travailler. Et donc, cette disposition de l'offre d'emploi nous a déjà intrigués. Et comme j'ai dit tout à l'heure, beaucoup de jeunes filles malgaches, surtout qui se trouvent sur la région côtière et les régions rurales, qui ont répondu à cet appel d'offres. Le recrutement s'est fait à Antananarivo, dans un hôtel, et il y a des personnes qui ont descendu sur place pour demander, recruter ces jeunes femmes-là, et qui ont transporté les candidates à Antananarivo. Une maison a déjà été visée pour accueillir ces jeunes femmes-là. Et après, on leur avait fait l'entretien et tout. D'autres personnes aussi sont déjà prison pour effectivement préparer les documents du voyage de ces jeunes filles-là. Il y a beaucoup de personnes qui s'occupent des passeports, des actes de naissance et tout. Il y avait aussi des faussaires parce que quelque part, certaines entre les filles, certaines d'entre eux n'ont pas de papier en règle. Ainsi, des personnes ont fabriqué des fausses cartes d'identité nationale, euh, des copies d'actes de naissance qui sont faux pour permettre effectivement aux jeunes filles d'aller à Maurice. Une fois les autorités malgaches, surtout la police, a eu connaissance de toutes ces activités, de ces recrutements et tout, ont tout de suite demandé, fait part de toute cette situation au parquet du tribunal et ils ont demandé de faire des perquisitions et des recherches pour établir s'il y a vraiment des infractions de traite. Une fois qu'ils ont eu le mandat de perquisition, ils se sont déplacés sur place et effectivement a vu les auteurs qui procédaient encore à l'entretien de ces jeunes filles-là et ont saisi tous les matériels informatiques, tous les documents qui s'y trouvaient. Et après, et la poursuite a été actionnée. Ils ont procédé aussi à l'enquête de l'affaire et on a pu trouver et établir d'après la recherche et les interrogatoires qui ont été faits que la société qui, comme on l'avait dit, que c'est une société qui transformait des poissons en Maurice, n'existait pas. Et on a traduit les soi-disant auteurs devant le tribunal et on a jugé l'affaire. Malheureusement, les investigations qui ont été faites n'ont pas permis de déterminer avec exactitude si les jeunes filles qui ont fait l'objet d'offres d'emploi vont être exploitées. Et deuxièmement, on ne savait pas. Après les recherches qui ont été faites, on ne savait pas de quelle exploitation ces jeunes filles vont faire l'objet vont être exploitées une fois arrivées à Maurice. Donc, pour Madagascar, on a adopté une loi 2014-040, et effectivement, adoptée pour lutter contre la traite des êtres. Et comme nous tous, on connaît très bien, la loi pénale sont d'une interprétation restrictive. Donc, on doit interpréter la loi d'une manière restrictive. Donc, par rapport aux éléments constitutifs de l'infraction, qui sont les actions, les moyens et l'exploitation, peut-être qu'il y a des recrutements, le transport, le transfert et l'accueil qui sont déterminés dans l'action. Il y a aussi peut-être des moyens, par exemple la tromperie, ou l'exploitation de la vulnérabilité d'une personne, mais l'élément exploitation fait défaut dans le cas que j'ai cité tout à l'heure. Ainsi, le tribunal malgache, le juge, a statué que les trois éléments constitutifs de l'infraction ne sont pas constitués après toutes les investigations. Donc, le tribunal malgache a statué qu'il ne s'agit pas d'une infraction de traite des personnes, mais par contre, on a qualifié l'infraction d'escroquerie du fait que les personnes, les soi-disant auteurs, ont ont utilisé des manœuvres frauduleuses pour avoir une somme d'argent parce que ces jeunes filles-là, on leur a demandé de payer une somme d'argent pour avoir le poste et de partir de Madagascar vers Maurice. Ainsi, ils ont peut-être trompé ces jeunes filles-là, comme quoi il y avait une société à Maurice qui demande des travailleurs malgaches alors que ça n'existe même pas. Et pour pouvoir avoir de l'argent, ils ont fait une offre d'emploi qui n'existe même pas pour avoir de l'argent seulement. Et les auteurs ont été condamnés sur cette chef d'inculpation et non pas sur l'infraction de traite. En gros et en résumé, ça s'est déroulé comme ça dans ce cas précis. J'espère que c'est un peu, j'ai bien expliqué le cas. Et vu le temps qui m'est imparti aussi, je ne peux pas m'étaler amplement. Merci.
Thank you very much, Madagascar. It's clear that we have a similar situation in Madagascar as we did in Zambia, and was it yes, it's clear that we have a similar situation as the situation in Zambia. So I hope the cases this morning have given us a bird's eye view of how different courts have treated the issue of intent. I think I can now hand over to Jepton because I think we can break.
Thank you, Lady Justice. Colleagues, I want to make a proposal that we move on to the next presentation and then we can make the tea break after that second presentation. Would that be acceptable? Or are the room energies very low? I look out to you so that we can have a democratic decision. All right, there's no strong feeling coming from the floor, so I think we can proceed to the second session of focusing on subtle means, led by the Kingdom of Eswatini, DRC, and Botswana. Then we can break for tea after that. Thank you very much.
But before the panel leaves, could we give them a very big round of applause? So again, as the next panel is coming on board, we are going to be looking at the subtle means of control, including family complicity. Most times victims are trafficked by people in their own families. And so we want to look at the complexities that arise in these situations. For those of you who wish to follow in your regional case digest, we're looking at 3.2.4. So if you want to look at the cases or you want to look at the issues independently, please turn to 3.2.4. So welcome Eswatini, which will be presenting, the delegation will be presenting the case of Jeremiah Dlamini and the case of Nzebele. DRC will be presenting the case of Luzama Kavu, and Botswana will be presenting the case of Muje. Again, I remind you, as you speak, please remember to look at me from time to time. We only have 10 minutes per presentation, and it would be great to stick to our time allocation. So welcome to the panel, and if we could start in the order in the program, Eswatini, then DRC, and finally Botswana.
Good morning, colleagues. I'm Sile Masugu. I'll be briefing the House on the Jeremiah Dlamini case, and my colleagues will handle the Nzebele case. This is one case wherein the subtle use of exploitation was conducted. In the Jeremiah Dlamini case, we have a father who's a 52-year-old man. He was a Zionist pastor. He was a traditional healer who had his private initiation room at the homestead. He was a local community police. He was also a local headman of the Women's Regiment. In a certain, we have men who usually lead the young girls during the Umhlanga dance. So he was head of that regiment. And he was a respectable man in his community. Jeremiah had previous wives who had deserted him and had many children. Amongst those children, he would take those children from their mothers and come and stay with them. So we'd see that the women that deserted him noticed that he was having sexual intercourse with his daughters. So the challenge was that in as much as it was known that he had sexual intercourse with his daughters, no one reported it. Instead, they'd desert him. So it went on such that when the sexual encounters started, one of the daughters was only 14 years old. So, and there's also a niece whose a daughter to the accused person's brother who was deceased, and the mother of that niece was also deceased. So he offered to take her in and stay with her. And with her again, the sexual exploitation started. So the girl who was 14 years old then ran away from home, came into South Africa in the Mpumalanga region, where he got married. And upon reaching that place, the father traced her and told her that life wasn't going to be easy for her, and the marriage would come to an end. And indeed, the marriage did come to an end, and she had problems, and she had to return home to the father. When she returned, she went to the grandparents' place, and he was left with the niece and another daughter whom he had collected from the mother's place as well, and the sexual encounter was proceeding. So when this daughter, who was now residing here in South Africa, came, he went and collected him and ordered her to go and stay with him at his home. On arrival, this older girl who was now 24 years, remember she ran away when she was about 14, now she's 24 years, she comes back, finds the cousin and the other sister. Now the situation was such that Dlamini was now being bathed, he was fed, he would just sit naked and the girls would take turns to come and bath him and feed him in the presence of the wife. So on this particular day when the matter was finally reported, this older girl was shocked to find that now the father was now being treated like a baby, being fed and bathed. Then after that, she would have sexual intercourse with him. So this one, on this particular day, the 24-year-old was called to come. It was her turn to bathe the father. And it would seem that when it was your turn to go and bathe your father, you had to go in that bedroom naked as well. So she decided no, she wasn't going to be naked. She was going to wear her skirt and her t-shirt. So when she entered the bedroom where she was supposed to bathe her father, there was an argument by the father asking, why are you dressed? Because you know how things are done here. So she was the one who got angry, packed her clothing and went straight to the police station to report what was happening in the household, and then she fled. So that was the only time then the police, because it wasn't something that was unknown, let us bring it to the house attention. It was known that this father was doing these things to his children, but due to his status and that he was a traditional healer who would also practice witchcraft, no one dared to touch him, such that he would tell those children that even if they reported, no one was going to do anything to him, because it has been going on for years. It had been a very, very long time. So this one then stood her ground and said, no, I'm not going to do this anymore, and she reported and she fled. So when we preferred the charges against the suspect, it was the rape, because there was this younger one, and the contravention of the Sexual Offences and Domestic Violence Act on the older girl. Then we did then charge him with the trafficking, the exploitation part, because our Section 12 of the Act states that a person who recruits, transports, harbors, receives, employs, maintains, or holds any person or persons for the purpose of exploitation by one or more of the following means: threat, use of force or other forms of coercion, abduction, fraud, deception, abuse of power or law or legal process, abuse of the position of vulnerability of a person to an act of trafficking, and giving or giving, receiving of payments or benefits, commits an offense and is on conviction liable to a term of imprisonment not exceeding 20 years. So I'm sure with the discussion of the prosecution, we decided that no, this section of our trafficking is covered by the offense that was committed on those children. Hence, we also charged him with the Trafficking Act. The court noted that indeed the father did use subtly means to exploit the children, and did convict him on that aspect as well. So in total, the accused person on the counts of rape, which is 1 to 4, because it was the same person, he was sentenced to 15 years imprisonment. On count 5 to 7, he was also sentenced to 15 years imprisonment. On the contravention of the Section 12 of the People Trafficking and Smuggling Act, he was convicted to 5 years. And on the other count, because there were 2 counts of trafficking, he was also sentenced to 5 years imprisonment. And on the SODV, on the contravention of the SODV, there was about 3 counts on that. He got 5 years, or with an option of 20,000 fine each. So in total, he was sentenced to 55 years imprisonment. Yes, and then the court noted that actually the family complicity was used to abuse those children, such that they felt like if they ever reported the abuse, their father was either going to kill them, and they'd have nowhere to go to, and no one was going to take care of their needs, like shelter, food, and clothing. So that is what the court noted in terms of the convictions. I think then I'll hand over to my colleague on the Nzebele case.
Good morning, colleagues. My name is Futhi Gamete. I am also a prosecutor in Eswatini. I'll be talking about the Nzebele case. This is a case of a man who was a pastor in his community. And let me mention that this case was dealt with at the subordinate court, which is a magistrate court in one of the regions in Eswatini. So this man was a pastor in his community, and one day in the year of 2012, he gave a lift to a certain girl who was 16 years old at the time. And as the girl was in the accused person's car, he got to know that the girl was not schooling because of financial constraints of the family. Her family did not have money to send her to school. So this man offered to pay school fees for the girl. He went to the girl's parents. They had an agreement that he will take care of the girl. He will actually pay school fees. And he also found out that the girl is owing book fees from a previous school and for previous years. He also promised to settle the debts on the book fees which were owed by the girl. And this man took this girl to stay with her. He also mentioned that as the girl was staying with her, she will also do duties of a maidservant. Apparently, the wife of this man was not staying with him at his home. So at his home, he was staying with his 8-year-old son and now this girl. And he made sure that he finds a school nearby his home where this girl will be schooling. He fetched the parents of this girl to come and see the school where their children will be the child will be going, and also to come and see his home, that indeed it was a good home for this girl. He will be able to live there with him. And then on one particular day, this man came to this girl's bedroom at night, and he would brush her whole body, and then he would return to his bedroom. And according to the girl, the accused then later came to his bedroom, removed her clothes, and attempted to penetrate her, but he could not succeed because this girl was not comfortable due to the pain she was enduring. And the accused made sure that he promised this girl that no, it will be okay. One day the pain will be normal and you will be fine. Then the girl also said that one night this man came to his bedroom and he was able to penetrate her, and he had sexual intercourse with her on many occasions. And this girl could not report this to anyone because she testified in court that she was afraid who's going to pay for her school fees, and that this man would chase her out of his home and he will discontinue to pay school fees for this girl. So, and she also knew that there was no food at home, and this man would then stop giving her food. So that was one of the means the accused person used to exploit the victim. And also the mother of the victim, she testified that indeed her girl was 16 years old, and the accused person came to their home and promised to pay school fees for this girl, and also that he seemed a trustworthy person since he was a pastor, so they didn't suspect anything foul about this man. Unfortunately, our court acquitted him on the charge of trafficking. He was charged with 2 counts, that of rape, our rape, which is in the Sexual Offences and Domestic Violence Act, since the girl was 16 years old, and the contravention of Section 12 of the People Smuggling and Human Trafficking Act. But the court acquitted him on the Trafficking Act on the basis that this man promised that he will take care of this girl, he will pay school fees for this girl, and he will also shelter this girl. And indeed, he did that. The girl went to school, and also the girl was allowed to visit home, so her parents would see her in school uniform and believed that indeed the man was taking care of the girl. So this is one of the means which are mentioned in the digest in 3.2.4.1, that in most times the perpetrators will use other means to lure their victims, which are means of good treatment. They will offer good treatment to their victims so that they can exploit them. And this, we see in our case that this led to the court exonerating the accused of this. And also the family complicity. The victim testified that he could not tell anyone at home about the exploitation because his family would think that he was lying because this man was trustworthy, and that he was also scared of the fact that she will be kicked out of the home. And also the fact that this man was a pastor. No one would believe that this man was really exploiting her. That is all.
Thank you very much, Botswana. We move on to DRC with the... Oh, sorry. Thank you, Eswatini. We move on to DRC with the Luzama case.
Je remercie la modératrice pour la parole. Mais contrairement à ce qui a été retenu dans le requêt de jurisprudence, vous allez remarquer que l'affaire qui est retenue dans le requêt de jurisprudence n'est pas très documentée. Il n'a pas été ressourcé par notre agence et nous avons préféré. Et ce matin, nous avons envoyé à Mme Jeptou un autre élément, afin de présenter un cas beaucoup plus documenté et qui comporte une décision judiciaire étoffée. C'est pourquoi nous allons présenter le cas qui vous sera balancé tout de suite et nous demanderons à ce que ça soit inclus dans le requêt de jurisprudence parce que c'est un cas qui est récent. C'est un cas qui est récent, qui est très récent. Il s'agit d'un jugement qui a été rendu à la province de Kwilu, plus précisément dans la ville de Kikwit, à 500 km de la capitale Kinshasa. Le jugement RP 52-94 du 7 février 2022. Donc c'est extrêmement récent et c'est un cas qui peut nous tous nous interpeller en ce qui concerne le trafic des enfants et particulièrement l'enlèvement des enfants ou le kidnapping des enfants, ce qui constitue en République démocratique du Congo un cas très récurrent. Mais avant d'aborder le sujet proprement dit, j'ai tenu à présenter le premier email que je lui ai envoyé, mais dans le tout dernier, le plus récent que j'ai envoyé, voulu parler de moyens subtils de contrôle progressif cas de la complicité familiale. Ce n'est pas dans ceci, donc si je tout me comprends, on peut balancer un autre email que j'avais envoyé. La RDC, ça c'est en termes de préliminaires, la RDC a mis en place des moyens de contrôle progressif pour protéger les victimes, victimes de traite de personnes, et en particulier les enfants. Et ces différentes mesures sont arrivées en 2009 avec la nouvelle loi portant protection de l'enfant. Et parmi les mécanismes qui sont mis en place au niveau de la Direction générale de migration, en sigle DGM, on impose un contrôle rigoureux des enfants au niveau des postes des frontières. Et ce contrôle consiste à ce qu'aucun enfant ne peut sortir des frontières de la République démocratique du Congo, ni être déplacé d'une province vers une autre province sans une autorisation officielle de la Direction générale de migration. Donc, sans cette autorisation, même si vous êtes le propre père ou la propre mère de l'enfant, vous ne saurez pas vous déplacer avec votre enfant, et c'est pour bloquer le flux des enlèvements et des kidnappings des enfants. Mais c'est un contrôle qui souffre de beaucoup d'impératifs, de beaucoup d'obstacles sur le plan interne, tant sur le plan même international, parce que les frontières de la République démocratique du Congo sont énormes. La République démocratique du Congo partage avec 9 pays frontaliers des postes de frontières, ce qui fait que le contrôle ne sont pas très assurés en ce qui concerne les déplacements des populations et en ce compris le déplacement des enfants. Et le contrôle, s'il est possible et rigoureux par voie des airs, ne l'est donc pas assuré par voie de route, en raison évidemment d'une superficie très large de notre pays, qui vaut 80 fois plus le Royaume de Belgique. Et au niveau de la loi, je peux même relever le code de la famille. Au niveau de l'adoption, parce qu'il y a des adoptions qui sont simulées en réalité au trafic d'enfants, on a évolué sur le plan de la jurisprudence et les décisions qui sont prises au niveau de la hiérarchie judiciaire veulent qu'aujourd'hui, on n'accorde plus ce qu'on appelle l'adoption in plano ou l'adoption plénière, c'est-à-dire qu'on cède l'enfant à la famille adoptive avec tout le droit possible. On garde un lien avec la famille qui envoie l'enfant afin de garantir que l'enfant ne sera pas victime de trafic ou de traite des personnes. Et le cas le plus illustré en la matière, c'est un cas qui est connu à travers le monde parce qu'il s'agit d'une affaire qui a été portée par la justice belge. C'est le cas de Madame Julienne Pembe, qui, en collaboration avec plusieurs centres de formation des enfants, avec des orphelinats installés en République démocratique du Congo, a pu, pour plusieurs parents, personnes se trouvant en Belgique, obtenir l'adoption de plusieurs enfants, un collectif des enfants adoptés. Mais pour que les enfants aillent au Royaume de Belgique, cette dame, qui est naturalisée belge, mais qui est d'origine congolaise, avait exigé des fonds, des finances, afin que ces enfants-là traversent la frontière. Et comme l'argent ne venait pas de la Belgique, elle s'est obligée de bloquer ces enfants dans des locaux à Kinshasa. C'est une affaire qui a fait grand bruit au Royaume de Belgique parce que la plupart des parents qui ont adopté en Belgique ont exigé la restitution de leur argent. Et cette dame a été condamnée, mais faute d'une bonne collaboration judiciaire avec la République démocratique du Congo, elle bénéficie, si j'ose croire, d'une libération conditionnelle à ce jour. Parmi les mécanismes de contrôle progressif de victimes qui tendent à diluer, à passer outre la complicité de famille, au niveau de la loi congolaise, on a renforcé d'abord l'arsenal des infractions au niveau du code pénal. Notre code pénal date d'avant l'indépendance, du 30 janvier 1940. On y a renforcé beaucoup d'infractions qui sont de nature à être relevées comme des formes de traite des personnes. Il y a l'esclavage sexuel, il y a plusieurs formes de violences sexuelles, telles que l'incitation aux pratiques pornographiques, aux danses obscènes, au proxénétisme, la stérilisation forcée, etc. Et au finish, la création de l'Agence pour la prévention et la lutte contre la traite de personnes est, je pense, le mécanisme le plus ultime qui permet, dans le cadre de la prévention, du contrôle progressif et, si vous voulez bien, des poursuites des actes qui constituent la traite de personnes, et dans sa mission qui consiste à intervenir pour tous les cas de traite de personnes, ça constitue en fait un mécanisme à travers une institution à intervenir dans tous les cas de traite de personnes et donc à veiller sur la protection des victimes de traite de personnes, en particulier des enfants. Nous allons passer à l'examen du présent cas. Rapidement, le présent cas consiste à 2 enfants victimes au niveau d'équipe 8, 2 enfants qui avaient faim et qui sont allés tout simplement au port d'Olonatra pour pouvoir s'alimenter. Et ces enfants, lorsqu'ils commençaient à ramasser de la nourriture au port d'Olonatra à Kikwit, ils ont été approchés par un certain monsieur qui s'appelle Roger Polo, qui, voyant que les enfants avaient faim, les a invités à manger chez lui. Et disposant d'une pirogue, M. Roger Polo a fait traverser ses enfants par la rivière Kouilou, les a amenés chez lui à la maison, les a fait manger. Ces enfants ont été rasés, ils ont été lavés, habillés, mais lorsque la nuit tombait, l'un des enfants, Fiston Matadi, qui était plus âgé, qui avait 11 ans, et l'autre, André, qui n'avait que 10 ans, ont demandé de rentrer à domicile. Mais on leur fait savoir qu'il faisait nuit, qu'il fallait dormir, mais on leur fera également savoir, pendant qu'ils mangeaient, qu'ils ne rentreraient pas chez eux, mais qu'ils iraient dans la ville de Kinshasa, où ils allaient servir comme de marchands d'eau, de sachets, et comme vendeurs d'huile de palme. C'est donc les fonctions qu'on devait leur conférer. Et dans la maison, ils ont été amenés par M. Roger Polo. Il y avait une dame qui s'appelle Kapinga Tumba, qui avait directement pris la direction, le contrôle de ses enfants, et qui leur parlait de leur acheminement dans la ville de Kinshasa. Il était avec son mari Omar Nganza, qui également a rassuré les enfants qu'ils iraient à Kinshasa pour servir de vendeurs. Mais dans le cadre de mécanismes de contrôle, comme nous avons dit, la police intervient souvent dans le cadre des renseignements. Et dans le cas d'espèce, c'est le 11e service de renseignement militaire de la province de Kwilu, et plus précisément de la ville de Kikwit, qui avait déjà eu vent que dans la résidence de M. Polo, que cette résidence-là constituait un abri de brigands, que ça constituait un poste, ou si vous voulez, un lieu de transit des enfants enlevés. Et lorsque la police a effectué sa descente, si je ne me trompe pas de la date, c'est le 4 août 2021, sur le lieu, très tôt le matin vers 5 heures, c'est alors que la police se rendra compte qu'il y avait 2 enfants enlevés qui étaient gardés dans cette maison. Mais on ne sait pas comment, M. Roger Paul avait déjà eu l'information, il avait déjà pris fuite, et le mari de Mme Kapinga Tumba, donc M. Omar Ngaza, surnommé Tarzan, avait également pris fuite, donc il n'était pas dans la maison. Donc, on a appréhendé dans cette maison 3 personnes, M. Litagi qui a pourvu à l'alimentation des enfants, Mme Kapinga, qui elle s'occupait des enfants, les apprêtait, les lavait pour les amener à Kinshasa, et on les a amenés à la police. Alors les enquêtes ont été diligentées rapidement au niveau de l'instruction juridictionnelle par l'OPJ William, et on a pu mettre la main sur 3 autres personnes, un certain Moukoulou Olivier, qu'on soupçonnait d'avoir caché M. Roger Polo. Lui également, Roger Polo a été arrêté parce que c'est caché chez sa copine. On a également pu mettre la main sur M. Omar Nganza, qui s'était caché également dans une autre résidence. Au niveau de l'OPJ, on a retenu à charge de toutes ces personnes. Au départ, ils étaient à 5, 3 infractions. Association des malfaiteurs, du fait qu'ils constituaient une bande organisée pour attenter aux personnes et à leurs biens. On a retenu également à leur charge l'enlèvement d'enfants, du fait que ces enfants étaient enlevés. Et on a également retenu à leur charge l'infraction de trafic ou, si vous voulez, de traite d'enfants. Les mêmes charges pénales ont été retenues devant l'officier du ministère public, si vous voulez, le magistrat du parquet, qui n'a pas tenu compte des explications des uns et des autres, parce que M. Moukoulou Olivier et M. Moulaï, qui étaient arrêtés pour raison d'enquête, disaient qu'ils n'avaient absolument rien à voir avec cette affaire et que la police les avait arrêtés juste pour raison d'enquête. Le ministère public, vu la gravité de fait, a pris soin de déférer toutes ces personnes devant le juge. Et au niveau du jugement, on parle directement du jugement, le raisonnement du juge a tenu compte de plusieurs faits. En remontant dans le fait de la cause, le juge a tenu compte de la manière dont les enfants ont été amenés chez M. Roger Mpolo. Mais je tiens à relever qu'avant que tous les prévenus ne soient envoyés devant le juge, l'auteur principal dans la résidence où les enfants ont été enlevés a pu s'organiser pour s'évader au niveau de l'officier de police judiciaire, donc au niveau du cachot de la police. Cela montre comment, au niveau du réseau en matière de trafic de personnes, comment ces personnes sont organisées pour fuir lorsque les poursuites sont engagées. Et donc, lorsque les poursuites ont été engagées devant le juge, l'auteur principal n'était pas devant la barre. Ont été jugés tous les complices qui étaient retrouvés dans la maison, y compris les personnes qui étaient arrêtées pour des raisons d'enquête. Et ce qu'il y a lieu de relever dans ce jugement, il y a plusieurs mérites, c'est que le juge a tenu d'abord compte de la comparution des témoins. Il a également tenu compte de la comparution des victimes, parce que les victimes devaient relater les faits tels que ça se passait, du moment où ils se retrouvaient au port au Natra, de la manière dont ils ont été pris par ruse pour atterrir dans la résidence de M. Roger Mpolo, jusqu'à l'irruption de la police pour l'arrestation de toutes les personnes qui se trouvaient dans cette résidence. Les témoins également ont été entendus, surtout à des charges en ce qui concerne les personnes qui étaient arrêtées pour des raisons d'enquête, M. Moukoulou Olivier et M. Moulaï, qui finalement ont été acquittés. Mais à charge de Mme Kapinga Toumba, c'est la seule femme qui était dans cette affaire, à charge de son mari, M. Omar Ganza, alias Tarzan, et à charge de M. Litadi, qui s'occupait de l'alimentation des enfants, on a retenu 2 infractions principales, mais en termes de complicité, parce que l'auteur principal étant M. Roger Mpolo, qui est en fuite jusqu'à aujourd'hui. On a retenu à leur charge l'enlèvement d'enfants, complicité d'enlèvement d'enfants, et la complicité de tentative de traite d'enfants, parce que les enfants n'ont pas été amenés à la destination finale. Ils ont été arrêtés au lieu de transit que constituait la résidence de M. Roger Polo. En ce qui concerne l'association des malfaiteurs, les dispositions de notre code pénal ne permettent la rétention de cette infraction que lorsque réellement il est relevé la preuve à charge de tous les prévenus qu'ils agissaient de concert, c'est-à-dire que chacun maîtrisait le rôle qu'il devait jouer et qu'il y avait un chef de bande. Cette preuve n'a pu être illustrée lors de l'instruction du dossier devant le juge, et donc cette infraction n'a pas été retenue à charge d'un seul prévenu. Les 2 personnes, Moukoulou Olivier et Moulaï, qui ont été arrêtés pour des raisons d'enquête, ont été déchargés de toutes les infractions et donc acquittés. Et donc, au demeurant, le juge a sévèrement condamné les 3 prévenus qui sont restés, Mme Kapinga, M. Omar Nganza et M. Litadi, à 15 ans d'emprisonnement. Chez nous, on appelle ça servitude pénale principale. C'est une expression qui est consacrée depuis la colonisation. Et donc, à ce jour, ce qu'il faut retenir de ce jugement, c'est que cela a permis des poursuites effectives en République démocratique du Congo, parce que nous n'avons pas encore une loi spécifique en matière de traite des personnes, en dehors de quelques infractions prévues pour les enfants en cette matière. Et cela permet également de relever des poursuites progressives et contrôlées par la police en termes d'alerte et de rumeurs, ce qui a conduit évidemment à sauver des enfants parce que leur mère n'avait pas assuré le contrôle parental voulu et organisé par le code de la famille. Je m'excuse pour le dépassement des minutes. mais l'affaire est tellement grande et comprend plusieurs paramètres et j'ai tenu rapidement à vous en faire état. Je vous remercie.
Thank you very much, DRC. Can we now finally hear from Botswana?
Yes, thank you. Good morning, everyone. Botswana will be presenting on the case of Saruzai Muje, a High Court decision that came out last year, 2021. The accused person in this case is a Zimbabwean national. She met the victim at Munzeiwa village in Zimbabwe, where the latter was resident. At the time, the victim was 16 years old and still a student. When the accused person met the victim's family was in dire financial difficulties. Her parents were struggling to provide her with appropriate day-to-day needs. On the day that the victim met the accused person, it was on one of those days when she did not go to school due to unpaid school fees. The accused person convinced the victim's parents to give her permission to travel with the victim to Botswana to seek employment as a domestic worker. The victim had no travel documents. The accused therefore smuggled her into Botswana and they ended up in a village called Prokwe, just in the outskirts of Gaborone. The two stayed in a two-roomed house and they slept in separate rooms. The accused person cautioned the victim against walking outside in the yard. She told her to remain in the house as she would be arrested by the police since she did not have a passport. On one particular day, the accused person called the victim into her room and introduced her to a man whom she said was her friend. After a short while, the victim left the accused with a friend and went to sleep. The following day, the accused person left the victim inside her room, promising to go and look for a job for her. That night, the victim was sleeping when a man came into her room and pushed her against the bed and then had sexual intercourse with her without her consent. The victim was able to tell from the voice of the man who violated her that he was the man who had been introduced to her by the accused person the previous day. In the morning, the victim told the accused person about what had transpired in the night, and that during the struggle with her assailant, she had tried to escape through the door but found it locked from the outside. The accused person denied any knowledge of the door having been locked or that she had locked the door. The following night, a different man came into the victim's room again and raped her. She again told the accused person about the ordeal, and the latter denied any knowledge of the incident. The victim's questioning of the accused person about this incident resulted in an altercation between the two, when the accused person told the victim that she was disrespecting her clients. The victim informed the accused person that she was going to report the matter to the police, and the accused person told her that she could not report because she was not a Motswana and that no one knew her, and even if she reported, the police would believe the accused over the victim. The accused also threatened to kill the victim, adding that her parents would never get to know that she was dead. She again warned the victim never to go outside as she would be arrested for being an undocumented migrant. Sometimes when the accused person was angry with the victim for complaining about the abuse, she would refuse to provide food for her for days. The victim was raped by different men every night for a full week. She did not know whether the accused was paid by the men who violated her. During trial, the second prosecution witness who stayed in the same yard as the two, told court that she once saw a man called Charles go into the victim's room, and that at some point she saw the accused person beating the victim with a stick. The social welfare officer who assessed the victim found that the victim was emotionally traumatized by different men who had raped her. The investigating officer told court that they had received a tip-off from an informer about a minor child who was being sexually abused in Tlokweng, and they followed up the report, and the victim confirmed the allegations. She was therefore taken to a hospital for medical attention. In defense of the accused person, it was stated that she had only beaten the victim in chastisement of her because she refused to take a job offer, and that she had introduced the victim to her housemates and her Motswana neighbor so that they could assist in looking after the complainant when she was not around. She denied that she was ever present when a man called Charles entered the victim's room. She denied looking the room from the outside when a man was allegedly inside raping the victim. She also denied telling the victim that she was disrespecting her clients, and further denied that she was the one who caused the victim to be exploited sexually by those different men. The accused person was charged with a single count of trafficking in persons, contrary to our Anti-Human Trafficking Act, number 32 of 2014. The maximum penalty for this offense is a fine of 500,000 pula or 25 years imprisonment or to both. The court found out that the victim was a credible witness, and it believed her testimony, having applied the cautionary rule. It found, therefore, that the victim had been recruited and transported from Zimbabwe, isolated in a room by herself, and exploited sexually by different men at the behest of the accused person. And therefore that from the circumstances, it could only be inferred that the accused person received some form of remuneration from those men for the sexual violation of the victim. She was therefore convicted as charged and sentenced to 10 years imprisonment. From the case, it comes out clearly that the accused person used the following subtle means of control. She isolated the victim. She used the victim's immigration status to instill fear of arrest, thereby succeeding in restricting her movements. She made her believe that she had no one to turn to. She discredited the victim by telling her that the police would never believe her. The victim was dependent on the accused person. Therefore, she would deprive her of food, thus making her to do her bidding in fear of the deprivation of food. She generally instilled fear in her by telling her that she would kill her and her parents would never know about it. As regards family complicity, the accused person made the family of the victim believe that she was going to find a job for her as a domestic worker. the parents believed that deception and therefore let the accused person have the victim and travel with her to Botswana. That is all from us.
Thank you very much, Botswana. We've heard from the participants, the delegations from the various countries that have submitted their cases, how traffickers use various means to control the victim. We didn't hear of the Luzama case, which is on the program, and basically that's another case in which children from impoverished parents were asked to assist a man clean his storeroom, and they would come and clean his storeroom, and thereafter he would then engage in sexual relations with them. So what we are seeing here is that the methods of coercion range. They are either subtle means where, you know, if you look at the Dlamini and the Nzebele cases, both, funnily enough, are pastors. And one of them is both a pastor and a witch doctor. Very interesting connection, very interesting. So he has powers from both ends of the spectrum. And these powers are so strong that, you know, the victims were too scared to report. And I think one thing that we got from the narration of this case was that when one of the daughters tried to escape, the father actually followed her and said, bad things will happen to you, and they did. So you can see the actual power that he held, that things didn't go well if he didn't bless those things happening. So you can see those subtle means of coercion. And then you move on to the Muje, which is less subtle. Yes, her freedom of movement was limited, but she was beaten. She was threatened, you're going to die and your parents will never know. And, you know, for us Africans, you want somebody to come to a grave and mourn you. And she was also threatened about her immigration status. So, you know, on that end of the spectrum, you know exactly what's going on. And the same thing with the Dlamini case and the Nzebele case, that, you know, the girls were worried that if they went away, who would look after them? So those basically are the sort of means of coercion that we're looking at. You see the differences in the court's approaches. It's quite interesting that in some cases, especially in the Nzebele case, the court found that the intention to traffic wasn't there because he only started exploiting the girl afterwards and not at the beginning. And yet these are the same subtle means of control that we're talking about. It's about grooming. You don't just jump in. And I think this shows us that as prosecutors, we have a very big responsibility. As courts, we are not aware of these things. We are not aware of issues such as, you know, these are specialist issues that are newly emerging. And if you want the court to appreciate them, you will have to explain, ideally with an expert, but if an expert is not available, then it is incumbent upon the prosecution to show somehow that this is how a trafficker operates. What you are using to acquit is actually the method in which the offense was committed. So thank you very much for a very successful panel. Thank you for the time you've taken to prepare. I'm sorry that we didn't have much time to hear about DRC's case, but they are going to provide the case and it will be recorded, and we hope for that it will be shared to everybody eventually. Could we give our panelists a very big round of applause? Jeptum, we are back over to you.
Thank you. Thank you very much, Lady Justice, and to the panelists from the Republic of the DRC, Republic of Botswana, and the Kingdom of Eswatini. Thank you really very much. I think we can take a 30-minute break. It's now 11:20. We can aim to be back here at 11:50. Would that be sufficient so that we could have one session that will take about 1 hour, because I think it's just 3 states, so that it would be 11:50 to 12:50, and then we can break for lunch at 1 p.m. On the schedule. So I hope that'll be fine. Thank you so very much. Enjoy your tea break.